Greetings to each and every one of you. I apologize for not being able to be with you in person online. This presentation will seek to highlight the trends and best practices associated with seeking to abolish the death penalty in Africa. It will focus on the role played by the African Commission on Human and People's Rights in advancing the cause of abolition and tap into some of my personal experiences in working with its special mechanism on this issue. The mechanism is called the Working Group on Death Penalty, Extrajudicial, Summary, or Arbitrary Killings and Enforced Disappearances in Africa. The death penalty remains an evolving and potent issue for Africa. Indeed, out of the 55 member states of the African Union, 15 states retain capital punishment within their laws in some form, while 18 states have placed a moratorium on executions and only 22 have legally abolished the death penalty. It is against this backdrop that the African Commission, in conjunction with its partners in civil society, has mounted a spirited campaign to steer the African Union member states towards full abolition of the death penalty on the African continent. As the continent's premier human rights body, the African Commission derives its mandate from the African Charter on Human and People's Rights. This consists of promoting, protecting and monitoring the implementation of the rights enshrined in the Charter. It is in the context of the right to life that capital punishment has remained a focal issue for the African Commission. In tracing the roots of the African Commission's work on ending the death penalty, I wish to call attention to its resolution urging states to envisage a moratorium on death penalty, which it issued in November 1999. In this instance, the African Commission embarked on an incremental approach, as it called on state parties to, firstly, limit the imposition of the death penalty only to the most serious crimes, secondly, consider establishing a moratorium on executions of the death penalty, and thirdly, reflecting on the possibility of abolishing the death penalty. In December 2005, the African Commission solidified its work on the death penalty by way of the resolution on the composition and the operationalization of the Working Group on the Death Penalty. Through this resolution, the Working Group on the Death Penalty enlisted expert members from civil society, and I was privileged to serve as one such member from November 2006 to August 2020. Our mandate, right from the outset, entailed elaborating a concept paper on the death penalty in Africa, collecting information and monitoring the status of the death penalty in Africa, submitting progress reports to the African Commission, as well as fostering collaboration with other stakeholders such as non-governmental organizations and national human rights institutions. In October 2012, the mandate of the working group was further expanded by a resolution to include extrajudicial, summary, or arbitrary killings in Africa. In November 2008, the African Commission issued yet another resolution calling on states to observe a moratorium on the death penalty. In the space of 9 years since the issuance of a similar resolution, the number of African states which had either de jure or de facto abolished the death penalty had risen from 19 to 27. With this steady positive trend, the African Commission embraced a more robust stance than in the 1999 resolution, calling instead for African states to fully support the working group in its endeavor to abolish the death penalty and to ratify the second optional protocol to the International Covenant on Civil and Political Rights on the abolition of the death penalty. Beyond resolutions, the African Commission, through the working group, then set out to engage states in promotional and sensitization efforts aimed at broadening continental support for the abolition of the death penalty. 2 notable meetings stand out in this regard. The first one, the first sub-regional conference for Central, Eastern, and Southern Africa, which yielded the Kigali Framework Document of 2009. And the second one, the second regional conference for North and West Africa, which yielded the Cotonou Framework Document of April 2010. In addition to affirming the ongoing approach of adopting resolutions, broadening partnerships, and furthering national dialogues, the Kigali Framework Document also contained the pivotal recommendation to embark on the development of a protocol to the African Charter on the abolition of the death penalty in Africa. The Cotonou Framework Document reiterated the centrality of the draft protocol in the working group's future efforts, as it outlined that the instrument would, quote unquote, fill the gaps and expand on the provisions enshrined in the second optional protocol on the International Covenant on Civil and Political Rights, as well as, and I emphasize, place stronger emphasis on restorative rather than retributive justice. As you may have noticed, the African Commission had steadily been on a trajectory which moved from a suggestive stance to a deliberate campaign of abolishing the death penalty in Africa. As I've already outlined, some of the promotional activities, as well as the elaboration of norms through the draft protocol, it is important to also acknowledge that the African Commission has had its protection mandate invoked in the issue of the death penalty. Indeed, the African Human Rights Case Law Analyzer database indicates that at least 14 cases determined by the African Commission raise the issue of the death penalty as being a violation of the rights protected within the Charter. My organization, my other organization, the Botswana Center for Human Rights, has been involved in 2 such cases, but I wish to call attention specifically to the case of Interrights and Ditwanelo versus the Republic of Botswana in 2015. This case is particularly interesting as it shows how the African Commission stance has evolved with regards to the compatibility of the death penalty with the African Charter. And I quote, "Given the evolution of international human rights law and jurisprudence and state practice, and cognizant of the progressive work undertaken by the Commission's own working group on death penalty extrajudicial summary arbitrary killings in Africa, the Commission considers it increasingly difficult to envisage a case in which the death penalty can be found to have been applied in a way that is not in some way arbitrary. As a result, it is difficult to conceive that if called upon in future to do so, that the Commission will find that the death penalty, however it is executed, is any longer compatible with the African Charter." This is also an apt point at which to highlight that civil society has been a vibrant advocate and partner to the actions of the African Commission aimed at abolishing the death penalty. Civil society has brought litigation before the African Commission, supported sensitization efforts at the national and regional levels, made oral interventions and sponsored resolutions during the ordinary sessions of the African Commission, as well as providing pertinent information during state reporting as required under the African Charter. One such illustrative milestone of civil society engagement was during the first Continental Conference on the Death Penalty, which was convened by the African Commission and the government of Benin in July 2014. This conference saw 78 human rights organizations sign on to the Human Rights Organization's Manifesto for a protocol to the African Charter on the abolition of the death penalty in Africa. This strong show of public support provided the necessary impetus which would see the African Commission adopt the draft protocol during its 56th ordinary session in April 2015 and forward it to the African Union member states for consideration. While the African Union member states are yet to adopt the draft protocol, due to various objections from retentionist states, civil society has remained a strong advocate for this cause, continuously engaging individual states and complementing the sensitization efforts of the African Commission's working group. In documenting trends and consolidating best practices in the abolition campaign, I can speak confidently of the notable activities undertaken by Ditwanelo, the Botswana Center for Human Rights, together with the International Federation for Human Rights, as examples of civil society's valuable role in this regard. In 2017, Ditwanelo, together with FIDH, the International Federation for Human Rights, which is a founding member of the World Coalition Against the Death Penalty, jointly published a document titled Triggers for Abolition of the Death Penalty in Africa, a Southern African Perspective. This was a study which identified the catalytic factors behind the trend of abolishing the death penalty in Southern Africa, with a view to informing advocacy approaches across the continent. Some of the key lessons which emerged from this study included, firstly, that it is essential to build a diverse and multi-stakeholder advocacy coalition consisting of human rights defenders, activists, judges, lawyers, parliamentarians, trade unionists, and youth movements, to name a few. Secondly, the quest for abolition requires political leadership and courage, and therefore it is essential to try and cultivate support at the highest levels of political leadership. Thirdly, political transitions, peace and reconciliation processes, and constitutional reform processes have provided opportune moments for the abolition of the death penalty. Fourthly, public opinion on the death penalty is not static, and it is influenced by various actors. victims of crime, affected relatives, and civil society. These can all foster dialogues which have an impact on public opinion towards abolition. It is also equally important to engage judges and parliamentarians, as their actions greatly influence public opinion. As I begin to conclude, I can say that at the end of my tenure within the African Commission's working group, I was left with reasons for optimism and great hope, even as I continue to acknowledge challenges which stand in the way of the abolition cause. I would list the following as reasons for my optimism. Firstly, the African Commission's working group has been reinvigorated by new membership, and its mandate remains a foremost priority for the Commission as a whole. This is seen in the May 2019 resolution on the abolition of the death penalty in Africa, where the African Commission reiterated its commitment to the abolition cause and authoritatively stated that the mandatory imposition of the death penalty was a violation of the right to life and right to human dignity. Secondly, on the 2nd of October 2019, Angola ratified the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. Thirdly, on the 28th of April 2020, Chad enacted a law abolishing the death penalty for terrorist acts. Fourthly, on the 18th of June 2020, the Senate of the Republic of Congo adopted a law authorizing the ratification of the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. And fifthly, Sudan's ongoing reform efforts has seen the repeal of the death penalty for certain crimes, including apostasy and homosexuality. The death penalty is also being abolished for children and people over the age of 70 years. However, some of the setbacks which stand in stark contrast to these successes include, firstly, the persistence of the application of the death penalty, with 57 recorded executions in 2019 in a number of countries in Africa. Secondly, the death sentence pronounced by the Bamako Anti-Terrorist Assize Court in Mali on the 28th of October 2020 against 3 jihadists prosecuted for the deadly attacks perpetrated in 2015 in Bamako. And thirdly, my own home country of Botswana. It continues to insist on carrying out the death penalty. With the execution of Mr. Moabi Seabelo Mabiletsa and Mr. Matsiriso Tsidi Wikanyo on the 28th of March 2020, as well as the recent execution on the 8th of February 2021 of Mr. Wedu Musalachai and Mr. Kutlo Siti. I conclude by making the following recommendations. Firstly, it remains essential to mount a continental coalition in support of the adoption of the draft protocol. This will entail continued sensitization on the provisions of the draft protocol among state and non-state actors, in the hope that the constituency of support will compel the African Union internal processes to move forward. Secondly, in the interim, it is important to expand the existing safeguards against the death penalty, key of which are ensuring the provision of legal aid and other judicial procedures which uphold fair trial rights for persons facing the death penalty, the institution of moratoria on the application of the death penalty as pathways to abolition are explored, and the commutation of death penalty sentences to life imprisonment. Thirdly, for states which have taken the critical step of ratifying the second optional protocol to the International Covenant on Civil and Political Rights, they should move to ensure effective domestication within their national laws by expunging those provisions which provide for the death penalty. And fourthly and finally, the champions of the draft protocol, who should ideally be a multi-stakeholder coalition, which I referenced earlier, should embark on an extensive and sustained dialogue on the contradictions between the death penalty on the one hand and the core tenets of the African Charter on the other, which include the right to life and the right to human dignity. Part of this conversation should also include the explorations of alternatives such as restorative justice. These conversations require political leadership and should be localized if public opinion is to decisively shift towards ending the death penalty in Africa.